Hi, and welcome to the Privacy Lawyer channel. My name is David Fraser. I'm a privacy and internet lawyer with the Canadian law firm McGinnis Cooper. I also teach internet and media law at the Schulich School of Law at Dalhousie University. The Information and Privacy Commissioner of British Columbia has just found that the City of Richmond in the British Columbia Lower Mainland broke the law when it installed ultra-high-definition cameras in public places that capture faces, license plates, and other identifiers. The Commissioner recommended that they take down the cameras and delete all the recordings. Now, the city said nope, so the Commissioner issued a binding order for them to stop collection, delete recordings, and to disband the system. Now, this is definitely going to court. The City of Richmond issued a statement saying they think it's lawful and appropriate, and they're looking to have the legality of this determined by the courts. And I generally think that's a good thing. The more clarity we have from the superior courts on the interpretation of our privacy laws, the better. I should note that while these laws are generally consistent from province to province, there is a big variation on how police services are delivered. Not all of the conclusions of this finding will necessarily be applicable in other provinces or municipalities. We'll start with looking at what Richmond did. So the City of Richmond in British Columbia began field testing its Public Safety Camera System, or PSCS, in early 2025 at the intersections of Minaroo Boulevard and Granville Avenue. The city's stated sole purpose was to collect and disclose video footage to the Royal Canadian Mounted Police to assist in identifying criminal suspects. That point, sole purpose, is central to the Commissioner's analysis. There is no other rationale for the City of Richmond to put up these cameras in these locations. Operationally, the system involved multiple high-resolution cameras capturing license plate numbers, high-definition images of vehicle occupants, pedestrians, vehicle identifying features, and location and time information tied to that particular intersection. The cameras would record continuously, and the city planned to retain the footage for 48 hours before deletion. The field test included capabilities like license plate recognition, pan, tilt, zoom variants, panoramic multi-sensor configurations, and other detection features. The city confirmed it did not use facial recognition or built-in audio recording during the field testing, though some of the cameras actually had those capabilities. The city's goal for the field test was essentially procurement and design. They wanted to evaluate the camera technology, decide numbers and placement, assess performance in different conditions, and confirm the PSCS could generate usable footage for law enforcement's later use. Now we're going to look at the statutory problem. You need an authorizing provision. Under British Columbia's Freedom of Information and Protection of Privacy Act, public bodies can't collect personal information just because it seems useful. Collection has to fit within a listed authorization, in this case Section 26 of the statute. In Section 26, Richmond relied on three possible authorities. Section 26 sub B related to law enforcement, Section 26 sub C, authorized program or activity and necessity, Section 26 sub E, planning and evaluating a program or activity. The Commissioner rejected all three, finding there simply was no legal authority for the collection of personal information, and without legal authority, there's no lawful collection. So let's look at the argument that they made under Section 26 sub B for the purposes of law enforcement. Richmond first said that they were authorized under Section 26 sub B, which says a public body may collect personal information only if the information is collected for the purposes of law enforcement. Note the use of the word only. Unless Section 26 permits it, a public body simply cannot collect personal information. Richmond's theory was straightforward. The definition of law enforcement includes policing, and the PSCS was meant to support policing by helping identify suspects. So it's for law enforcement. That was their alleged purpose. The Commissioner accepted that there's a connection. The information might be used by the Royal Canadian Mounted Police in policing. But the Commissioner says that's not the end of the inquiry, because the collector in this case is the city, and the city itself must have a law enforcement mandate of its own to rely on Section 26 sub B. This is a recurring theme in Canadian privacy oversight. A public body can't bootstrap a law enforcement collection power merely because another entity with a law enforcement mandate might find the data useful. The city may pay for law enforcement, and it may provide resources to law enforcement, but they do not themselves have a lawful law enforcement mandate. The report describes three main arguments that the City of Richmond advanced. Number one, the RCMP's mandate should be imputed to the city because the city, quote, provides policing by contracting with the RCMP for the RCMP to do the policing. Second, they say the city has a mandate to collect information for the RCMP. And three, the city has its own independent mandate to police through the cameras. The Commissioner's response is pretty technical. Under the Police Act and the Municipal Police Unit Agreement framework in the province, municipalities fund and resource policing. But policing authority and law enforcement functions remain with the police, operating independently of the municipality. The Commissioner underscores that the Police Act sets out specific ways a municipality provides policing, such as establishing their own municipal police force or entering into a contract with the RCMP. And that's different from running a surveillance camera system for the police to use. That's not among those statutory options. The Commissioner also points to the RCMP's peace officer functions and the Municipal Police Unit Agreement structure as vesting law enforcement responsibilities entirely in the RCMP, not the city. And he reads the legislative setup as intentionally keeping policing independent from municipal control. So this argument advanced by the city failed. The city simply lacked the necessary law enforcement mandate, so it could not collect under Section 26 sub B, even if the police might later find the footage to be useful. Next, the city tried to rely on Section 26 sub C. Section 26 sub C is the classic public body operational authority provision. Even if a statute doesn't explicitly say collect this kind of personal information, a public body can collect personal information if it is both directly related to an authorized program or activity and is necessary for that program or activity. Richmond framed its program as essentially an intersection camera program to identify criminal suspects following criminal incidents, pointing to broad service powers under its community charter. But the Commissioner rejected that program characterization as authorized because, again, of the Police Act structure. In the Commissioner's view, quote, collecting evidence to identify criminals that the RCMP may rely on, unquote, isn't part of how the city is authorized to provide policing services or resources under the Police Act framework. So the analysis fails at the first step. If the underlying program isn't authorized, Section 26 sub C can't save that collection. The report goes further and addresses necessity. The Commissioner emphasizes that the city's record was limited in establishing that unresolved crime was real, substantial, and pressing, or existing measures were ineffective, or less intrusive means had already been seriously examined. The Commissioner characterizes the intrusion into privacy as vast, relative to the limited evidentiary foundation offered to justify the necessity of the program. The net effect was that the Commissioner was not satisfied that the city demonstrated that mass capture of high-definition identifying footage from tens of thousands of people each day who had nothing to do with any sort of crime was necessary for the purported municipal activity. Richmond also argued the field test is just planning and evaluation, and Section 26 sub E specifically authorizes collection necessary for planning or evaluating a program. The Commissioner's treatment of the 26 sub E argument is crisp. 26 sub E presupposes that the program being planned or evaluated is otherwise authorized. You can plan or evaluate an authorized program, but if the program ain't authorized, you can't collect personal information to plan or evaluate it. Richmond itself largely accepted that position, and the Commissioner agreed. Because the Commissioner had already found that the PSCS was not authorized under 26B or 26C or any other law, Richmond could not rely on 26E to do planning for an unauthorized program. It really makes sense that you can't use the planning evaluation clause as an end run around the core requirement of lawful authority. Otherwise, everything under the sun could be said to be planning or evaluation. The Commissioner also faulted the city for inadequate notice. FIPA generally requires notice of purpose and authority when collecting personal information, and Richmond tried to avoid notice by invoking Section 27 sub 3A, the idea that notice is not required when the information is about law enforcement. The Commissioner gives two responses. First, the city can't rely on law enforcement as its underlying authorization in the first place, so that alone undermined the attempt to rely on that exception. Second, and more fact-specific, during the field test phase, the city had confirmed that it was not using the information for actual public safety or enforcement purposes, only to test and evaluate camera technical capabilities. So even reading about law enforcement broadly, the Commissioner questioned whether the testing phase collection qualified as about law enforcement because it would not be used to enforce any laws, and there is no compelling enforcement purpose weighing against notice. Now, Richmond did install signs, but the Commissioner describes them as a courtesy and finds them legally inadequate. The sign said, "Public safety camera testing, field testing in progress at this intersection," with contact information for the city's Director of Transportation. The Commissioner's critique of this is twofold. First, there was a content deficiency. The signs did not clearly notify people that cameras were recording and collecting personal information, and they did not include the purposes and legal authority for collection as required by the law. And secondly, there was a placement deficiency. Signage was vehicle-focused, placed for eastbound and westbound approaches, but did not address entries from other directions. And there was no notice to pedestrians, despite the system's capacity to capture pedestrians and pan widely, including multi-direction recording. The Commissioner's conclusion is direct. The city did not adequately notify individuals when it collected their personal information during the field testing. So at the end of all this, the OIPC's recommendations were blunt. 1. Stop collecting personal information through the PSCS. 2. Delete all recordings. And 3. Disband the equipment. Richmond advised that it would not comply, and the Commissioner issued Order F26-01 requiring immediate compliance and written evidence of compliance by a specific date. So next stop is the courts. My takeaway is that the Commissioner's reasoning is primarily structural and jurisdictional. The city tried to create a surveillance for police capability, but the Commissioner reads BC's legal framework as drawing a hard line between municipal services and police law enforcement authority, particularly when the activity is mass surveillance in public space. If you're a public body contemplating pilot projects with high capability cameras, the report is a reminder that planning provisions don't let you pilot an unauthorized program, and that law enforcement adjacent doesn't equal law enforcement authorized. For a public body, every collection of personal information has to be directly authorized by law. It's worth noting that the law enforcement provision in most public sector privacy laws is wide enough to drive a truck through. The RCMP in Richmond could have paid for and put up those cameras all over the place, since they themselves have a law enforcement mandate. Criminal courts are pretty adept at dealing with privacy invasions on a case-by-case basis using Section 8 of the Charter, but we actually need a better way to evaluate proportionality, necessity, and appropriateness when it comes to proposed police programs that hoover up data on hundreds, thousands, or maybe millions of innocent people in the name of law enforcement. It will be very interesting to see how the court deals with these particular questions. So that's all I've got for you today. I hope this has been interesting and maybe even useful. I try to put out a new episode every few weeks, and sometimes sooner if something riles me up. If you're watching this on YouTube, you should know that this is also available as a podcast. Just search PrivacyLawyer, all one word, on your preferred podcasting app. And if you're listening to the podcast and you want to see the flashy graphics and CGI effects, you can find it all at youtube.com/@PrivacyLawyer. I also put a transcript on my blog at blog.privacylawyer.ca if you like to read words on a screen. Now, however you get this, please click the like and subscribe buttons. Also leave a comment if you have any questions or if you have any suggestions for other topics to cover. And of course, feel free to share this with anyone who you think may be interested in hearing about Canadian privacy and technology law. Thanks for tuning in.